September 4th was supposed to be the day that the FTC's final rule eliminating non-competes nationwide would take effect. That's this week. So where do things stand now? Hey everyone, welcome back to Employment Law After Hours. Today we're diving into the hot topic that's been making waves in the business world: the FTC's final rule banning non-competes nationwide. We will explore what this rule entails, its potential impact, and the latest updates on its enforceability in this week's episode. So let's get started. Let's jump right into what a non-compete actually is. Essentially, a non-compete is a standalone provision or its own contract, typically containing employment or independent contractor agreements that essentially prevent the employee or worker from working for a competitor or other similar business upon their departure from that employment or working opportunity. These agreements are typically for a certain period of time and often restrict employers that are competitors within a certain radius of the existing business. In essence, non-compete agreements are used by the original employer to protect their business interests, their trade secrets, and confidential information when an employee leaves that employment and goes to the new employer, right? They don't want that employee taking that confidential information or other trade secret protections with them and then using that information to compete against the original employer. However, non-competes have come under intense scrutiny over the last couple of years as more and more states, and now the federal government, wish to either limit them or seek their enforceability altogether, which brings us to where we are today with the FTC's rule banning non-competes on a nationwide scale. The FTC isn't really alone in this final rule, though. Other states such as California and Oklahoma and even Minnesota have enacted provisions that severely limit or otherwise restrict non-competes from being enforced at all. Other states such as Colorado put severe restrictions as to when an employee and which employees may have these non-compete agreements. The FTC essentially says on a nationwide scale at the federal level, hey, we're not interested in trying to limit which agreements can be put in place. We're interested in banning non-compete agreements nationwide. The FTC's argument here is that non-competes really limit where employers can work, which obviously that's their intent, but by doing so, they're suppressing wages and innovation in industries. The FTC is saying that when this final rule goes into effect, it's going to result in at least 8,500 new businesses being formed each year and a significant increase in wages for workers as there will be more competition in the marketplace for those employees. Meaning the original employers are going to be incentivized to increase pay, benefits, and other opportunities to ensure that those employees, stay with them. On the other hand, with non-compete agreements in place, these original employers can essentially say, well, hey, you're not going to leave us because you got nowhere to go. You're stuck with us unless you want to uproot your family, change their schools, find a new house outside the jurisdiction of those non-competes. And therein lies the intent for the Federal Trade Commission's final rule that they finally put in place in April of 2024 this year. However, based on the language of that rule, it's not supposed to take effect until September 4th, 2024. Again, this week. So let's talk about what's actually contained within the FTC's final rule banning non-competes. Essentially, as of September 4th, original employers, are not going to be able to enter into any new non-compete agreements with any workers that they have, regardless of the position they hold or how much they make or how long they've been there or what sensitive information they're privy to. Essentially, as of September 4th, that's going to be the new rule. No new non-competes for employees. Now, this rule does extend also to independent contractors, volunteers, interns, as long as the people being restricted are individuals and not companies. They're not going to be able to have new non-compete agreements that are formed. So you may be asking, well, what about existing non-competes? Hey, I have employees that have non-competes that we had them sign when they get started. Well, as of September 4th, except for a select few number of employees that we'll discuss here in a moment, those non-competes can no longer be enforced. Essentially, what they're saying is, we don't care that you had these existing agreements. We don't care what consideration was entered into to get those agreements. They're no longer going to be enforceable as of September 4th. Now, what about the small subset of employees that are going to be exempt from the existing non-compete prohibition? Essentially, what the rule says is that senior level employees, essentially C-suite employees, executives, high ranking managers, that are essentially running the show and dictating policy for the company, they can still have their existing non-competes enforced as long as they make a little over $154,000 a year. However, it must be noted that even if you're a senior level executive, CEO, whatever it may be, you can't have any new non-competes entered into as of September 4th. Essentially, for this small subset of employees, they're the ones that are going to be grandfathered in, no one else. There is one other exception that I want to discuss for a moment. In the final rule, the FTC did take steps to ensure that exceptions were made for people that were selling a business. And essentially what that means is companies can still require that if they purchase a business from an individual, that individual be bound by an otherwise enforceable non-compete agreement. That way we ensure that company is still receiving the value of that purchase. Therefore, if you're selling a business or you're a company that's buying a business, just know that non-compete agreements may still be enforceable against you. Again, get in contact with your attorney to discuss the enforceability of that agreement or those provisions, especially during that negotiation process. The final rule also states that these employers that have individuals with non-competes, they have to issue a notice to them on or before September 4th, essentially saying, hey, as of this date, we're no longer going to enforce this non-compete against you. We've begun preparing these model notices for our clients to use. However, the FTC does have existing models for these notices that some companies are choosing to use, but we recommend that you consult with your attorney or HR supervisor to discuss what language is best to ensure the employers are still able to protect themselves and their secrets as much as possible, while also complying with the requirements of the final rule. It's important to note that the FTC does not intend through this final rule to limit non-solicitation agreements, confidentiality agreements, trade secret protections. Those will still remain enforceable for everyone after this date, as long as those prohibitions don't have the effect of punishing someone just for leaving the current employment to go to a new competing employment. Otherwise, those agreements, those provisions are enforceable. We'll plan an episode at a later date that really discusses what non-solicitation agreements are and how employers can craft confidentiality and trade secret protections to ensure the most protection, especially in light of this FTC's final rule. Now, here's where things are going to get a little interesting. Obviously, the final rule was set to take effect on September 4th. However, just a couple weeks ago, the Northern District of Texas, through a litigation action that was previously filed, has ruled that there is a permanent stay on the implementation of this final rule, which means this court is now saying nationwide, employers don't need to worry about following this final rule. Now, there's some arguments out there about whether the Northern District of Texas has this authority, but we expect that based on this decision and how courts have handled other similar enjoinments, that most courts are going to follow the Northern District of Texas and not require employers to follow this rule. We recommend that you speak with your attorney to ensure that you can forego the implementation of the final rule. But at this time, most companies are adhering to the Northern District of Texas's injunction and saying, hey, we're not going to follow the rule at this time, pending further court action, either from appellate courts or from the FTC that changes the rule that otherwise requires new implementation of provisions. As of this date today, which is September 3rd, 2024, no courts have reversed or otherwise amended the Northern District of Texas's injunction. Therefore, from our perspective at least, this injunction remains in place nationwide, which essentially means for companies and employers that the final rule banning non-competes nationwide is not currently enforceable and no actions need to be taken at this time. Again, with the caveat that we're not your attorneys, therefore you should speak with your own attorney to see if this applies to you. Let's spend a moment talking about what this actually means for employers. The FTC's final rule was one that was teased by the Biden administration for quite some time. And we were actually surprised when a final rule was issued, especially when it banned non-competes nationwide with very few exceptions. But this really begs the question, what should employers be doing going forward, even if the final rule is stayed and these restrictions are not enforceable? There's been a growing wave across the country, particularly at the state level, that otherwise seeks to limit or prohibit non-competes. As I said, there are states that have already started to limit these, and it really doesn't fall on party lines. Blue states are doing these prohibitions on non-competes in red states are doing. It's really an issue that transcends party lines. For this reason, employers really should be speaking with their attorneys and HR advisors to talk about ensuring that their non-compete agreements that they have in place right now are currently enforceable, given the state restrictions and court restrictions, and whether changes need to be made to those non-competes to ensure that, yes, although they're enforceable at the federal level, are they going to remain enforceable at the state level and in the court jurisdiction that those employers are located. At the same time, take this opportunity to evaluate and discuss changes that may need to be made to an employer's non-solicitation agreements, confidentiality, and trade secret protections as well. Those are awesome provisions that employers and companies can use to really protect their client base, their employee base, and their secrets. Those provisions, although not as limited as non-competes, do also have state and court level restrictions that need to be abided by if you're going to implement those provisions. That's not to scare anyone away or say that you shouldn't implement non-solicitation and trade secret protections, but to ensure that the language that you're using is otherwise crafted to such an extent that they're going to remain enforceable. In essence, the FTC's final rule that banned non-competes nationwide was really a bold approach aimed at fostering competition and employee benefits for years to come. Although this final rule it stayed from enforcement at this time by the Northern District of Texas, we don't think that this is going to be the end of the conversation. We do expect more states, more court jurisdictions to continue to enact limitations on non-competes or outright banning them. And we may even see the FTC revisit its final rule, make changes to it in such a way that it would pass this judicial scrutiny and otherwise allow it to be enacted on a nationwide level. But we really appreciate you taking the opportunity to tune in to this episode of Employment Law After Hours. We look forward to our future episodes discussing restrictive covenants such as non-solicitations and providing further updates as non-compete ban changes, were enacted nationwide. Therefore, take the moment to subscribe down below for free so you don't miss those important updates. And while you're there, let us know down in the comments, not legally protected communication, of course, but let us know down in the comments, do you have a non-compete that's applicable to you? Does your company employ non-competes to restrict employee movement? Is this really a nationwide issue that needs to be discussed? Let us know below. We'll see you again next time.